Good evening and welcome to Legal Talk, the talk show brought to you by the law offices of O'Donnell, Weiss and Mattei. Excuse me. Your life, your business, your law firm. We're at 41 High Street in Pottstown. We're at 347 Bridge Street in Phoenixville. And our website is owmlaw.com. My name is David McGay, and I'm one of the attorneys at OWM Law. And tonight I'm joined by, to my immediate left, Rebecca Hobbs. Rebecca, thanks for joining us.
Thank you.
And to Rebecca's left, Jim Kovaleski.
Hi, Dave.
Folks, tonight we're going to talk about estate planning. And we're going to talk about the pros and cons of having estate planning documents. We're going to talk about what are necessary estate planning documents. We're going to talk about what you should consider in your estate planning documents. And then finally, we're going to talk about the consequences of not having the estate planning documents. So the first thing I want to throw out there is to Rebecca, who needs estate planning documents? My kids are 19 and 16. They're not, well, they were a long time ago, but they're 19 and 16. Do they need estate planning documents?
Mm-hmm. Yeah, so in my opinion, everyone over the age of 18 needs an estate plan.
It was like a law school exam I gave you. You
know
know where I was going with that. One's 19, so he's over the age of majority. The other
right.
one's, okay, so you're on it. You're on it. Yeah.
So definitely the 16-year-old can't yet plan for incapacity or create a will because they're not of legal age yet. But the 19-year-old definitely, at 19, kids are getting ready to go away to college if they haven't already, and that would be a good plan, a time to make sure that they have at least a power of attorney document in place, which we'll talk about.
Okay. Jim, why the heck does my 19-year-old, Rebecca just said my 19-year-old needs a will and powers of attorney. My 19-year-old has a piece of junk car. I don't even know if it's in his name. Let's say it is, and he has $100 in his checking account. Why does he need a will and powers of attorney? So I'm busting on Rebecca here a little bit. Why do you think the 19-year-old needs one?
Well, I think I'll start with the powers of attorney because I think in that situation, particularly, they're going to be the more important documents. Those documents will allow your son or daughter or whoever it is that's signing the documents to appoint an agent to act for them if something happens. Maybe they're out of the country, maybe they are become incapacitated, or they just, I think back especially with the medical power of attorney, I had a surgery a couple of years ago. My wife, who's my agent, would have had the authority to act if something had happened under my medical power of attorney. So those two are really important for any individual because you're appointing an agent that is able to speak and act on your behalf if you can't. With the will, still important, still very important. I just put it under because of the size of the estate. There's not as much of an issue in the sense of there's an intestacy statute that will direct what happens if you don't have a will. But the great thing about a will is you can actually say specifically who's going to receive property, who's going to be in charge. So even at that young age, they can make those decisions to make sure that the right people end up in the right positions and receive the right things under their will.
So it really doesn't matter the size of the estate.
No.
It's the reasons for it. If you die and you have an asset in your name only, you need a will to dictate who gets what. And we'll talk about intestacy, and that's a phrase you use or a term you use. We want to talk about that a little bit later. And even if you don't die, if you become incapacitated, I don't care if you're 18 or more, someone needs a power of attorney, your parents or maybe your sibling, older sibling or whatever, needs a power of attorney to be able to take care of your document or take care of your financial needs and your, what else, healthcare needs, right?
Yes.
Well, Rebecca, let's talk about in more details the exact documents that someone needs. Or what, in addition to a will, what else would it be?
Yeah, so there's really three basic key documents that everyone should have. And that first document is your last will and testament. And like we discussed, that kind of controls upon your passing, who you want to get your property, how you want that to be disposed of. But also it's really important where you have minor children, because you can appoint a guardian for the minor children, and that can be really the primary reason you're doing a will also, if you don't have a lot of assets to dispose of, but you have minor children and you want to direct who would care for those children in the event that you passed away. But aside from your will, the other two really important key documents are your financial power of attorney, so a durable financial power of attorney, and then a healthcare power of attorney that also includes a living will. So those are the three basic key documents that everyone should have. And that financial durable power of attorney, we talked about that a little bit, but that really is appointing an agent that can kind of step in and handle your finances if you're not able to do that anymore. And that's really important for individuals, not only if you're traveling and you need a spouse to be able to handle something for you, but if you would get into a car accident, God forbid, and become disabled and not be able to manage your money anymore, or as we age and potentially develop different kinds of dementias, then that document can be really important to have. Along with that healthcare power of attorney, where the financial one is appointing an agent to handle your money for you, the healthcare power of attorney is appointing an agent to make decisions for you in the event that you're not able to do that.
All right, I want to hit Jim with two points that you brought up. One is, Jim, what the heck's durable? What does that mean?
Durable. So that's it's one of those words where lawyers get a hold of, and can have a whole completely different meaning than what you might think it is.
But I hear that a lot from people. People come into me and say, "I want a power of attorney, but I want it to be durable," as if it wouldn't be otherwise. But you tell us, what does that mean?
So basically, the easiest way to explain it is that it's durable, meaning it's going to last until usually one of two things happen. You either revoke it or you pass away. If you revoke it, obviously the power of attorney goes away and the authority granted goes away. If you pass away, and this is a common misconception I get, that people think that they can act under a power of attorney, so the agent can continue to act after the principal, the person who gave the power, passes away, and that's not true. That document dies with the individual that made it. So if either one of those things haven't happened, and there's a couple other minor things out there, it's the power of attorney is going to continue to exist. The power granted is going to continue to be able to be used, and it's going to be durable, meaning it's going to continue.
But I don't want to, Jim. I don't want to sign a power of attorney today that gives someone else the right to make medical or financial or both decisions for me, because I want to retain that right to make those decisions my own.
Even if you grant the authority under the power of attorney, you still retain the authority to make those decisions on your own. All that means is, so I'll take my wife and I as an example. So my wife is my agent under my power of attorney that we signed. I don't even remember the last time we did the documents. So she could go to the bank today, and if our accounts weren't joined, if I had an individual account, she could take that power of attorney today and do something with that account, write a check, make a deposit, make a withdrawal.
Wipe you out.
Wipe me out. But I could do the same thing. So those powers, that ability to act, coexist essentially. So the question is, for me, is that, or the question I pose is, do you trust your agent under your power of attorney? Is it somebody that you believe that is not going to wipe you out in the wrong circumstances?
Right.
That's really the quintessential question for me when I'm meeting with clients is, if you have any doubt, then that person shouldn't be your agent.
Yeah, that's a great point. I do the same thing. You try to read the client, and you look behind their eyes, and if they show any doubt, I ask the same thing. If I say the same thing. If you have any doubt that the person that you're choosing is going to do what's in your best interest, not commingle your assets and not wipe you out, then you got the wrong person.
Absolutely.
But Jim, I don't want to give up my right to act.
You're not giving up your right to act just because you've given somebody the authority under a power of attorney. As long as you have capacity, you have the right to act, and you can have the right to revoke that power of attorney, to do another one, to do whatever you want. You never give that up when you sign a power of attorney.
Okay.
You're just authorizing someone to act in your place.
But Jim, I don't want my brother to be able to do anything until I become incapacitated.
Okay, well then that's a different story. There is a second type of power of attorney. We commonly refer to it as a springing power of attorney.
Which is the opposite of durable?
Exactly.
Okay.
Meaning durable means it's in effect once you sign it, and it's in effect until you either revoke it or die. Springing means that something has to spring or occur in the future before that authority granted is actually granted. Oftentimes it's linked to capacity or something like that. The concern that I have with those documents, and I do use them on occasion, is that if we put a springing event in there, we have to prove that that springing event occurred, which can be sometimes even a legal battle with litigation. So if we tie it to incapacity, and the person that granted the power of attorney, if they don't believe that they are incapacitated, you might end up in court with experts and doctors and people putting on testimony as to whether or not that occurrence has sprung.
So really, what's the use of having one?
That's generally my standpoint.
Right.
Is that I'd rather make sure that I'd rather use a durable. I'd recommend you use a durable and just trust the person you appoint and be a gatekeeper of that document. Meaning, the person doesn't need to have a copy of it. They don't need to have the original.
Right.
What they need to know is that you've asked them to act as their agent. They've accepted. That's a key concern, and they know how to access it if something does happen to the principal.
Rebecca, but I don't want to do my documents yet because I haven't talked to my brother about whether he should be the power of attorney. And there's no right or wrong answer, and I'm springing.
Right.
Sorry, I'm springing this on you.
Yeah.
But and we may have opposite viewpoints, which is completely fine. I'm not a big fan of telling my brother ahead of time, which goes against what you just said a second ago. Because if I call my brother and said, "Hey, buddy, just want you to know I named you as my POA, I named you as the guardian for my kids, if my kids were minors, etc." He would say, "Great, brother, wonderful, I'm honored." He could hang up the phone and look to my sister-in-law, and she says, "Who was that?" "That was my brother. He asked me to be his kid's guardian. I'm not going to do it, but I didn't have the heart to tell him." So I'm not a big fan of telling. And guys, there's no right or wrong answer. I think Jim and I may disagree on this, but if I've told my brother, he says he'll do it, but there's no guarantee he's going to do it.
Right.
He could when I die or become incapacitated, he could say, "I'm not doing that." Second of all, if I change, if my brother makes me mad, which he tends to do once in a while, I could change and point my sister. Don't I need to call my brother back and say, "Hey, buddy, remember back in spring of 17, I asked you to be my power of attorney, but no more." So where do you fall on that?
Yeah, so I think
hopefully in the same way I feel, then I feel better about that.
I mean, I think that each family situation is different, so I think that you have to look at the situation. I know for me personally, I did make the phone call to my sister. We appointed her as the guardian for my children, and asked her, because I wanted to make sure that that was something that she felt comfortable doing. So I think there are two ways that you could go. I'm of the opinion
So
that
you don't agree with me, is what you're saying.
I don't, but I do see some situations that would make sense to do it that way. I do think that it's very important to make sure you always have at least one alternate agent or executor, guardian named, if not a couple different alternates. So that way, in the event you do appoint somebody, and maybe circumstances change and they're not in a place in their life where they can step in and be that person for you, then you have a backup. And I think that's important to make sure you build into your plan.
You want to say something?
I was, and I'm going to spring this on you, Dave. What you don't know is I didn't
You better do it quickly because we got like 40 seconds before the break.
You don't know this, but I didn't even follow my own advice when I did my documents. You're really my agent and my power of attorney and my guardian of my two children.
Yeah, been there, done that. No thanks. Okay, what I'd like to do, let's break. This went way too quick, but on the other half of the show, guys, on the other side of this commercial break, I want to talk about the need to coordinate beneficiary designations with the will. We'll do a minute or two on that. Then we'll talk about the consequences, folks, of what happens if you don't have a will and don't have powers of attorney. You're watching Legal Talk, brought to you by O'Donnell, Weiss & Mattei. Please stay tuned for the second half of the show.
For over 50 years now, O'Donnell, Weiss & Mattei have helped their clients resolve a wide variety of legal challenges. OWM Law provides legal representation to clients throughout southeastern Pennsylvania. The attorneys and highly trained support staff utilize the latest technology and resources available to satisfy the needs of their clients. O'Donnell, Weiss, and Mattei, delivering the highest level of professional service.
Welcome back to Legal Talk, the talk show brought to you by the law offices of O'Donnell, Weiss, and Mattei, or OWM Law, your life, your business, your law firm. We're in Pottstown at 41 High Street, and we're in Phoenixville at 347 Bridge Street. You can also, and you should, check out our website to learn a lot about our practice, our history, and each of our 12 attorneys, I think, guys? 12 attorneys at www.owmlaw.com. I'm Dave McGay. I'm joined tonight by Jim Kovaleski and Rebecca. And we're talking about Rebecca Hobbs, and we're talking about estate planning, wills, and powers of attorney. First half of the show, we talked about who needs wills, who needs powers of attorney, which is everybody over 18, right? And then we talked about how the documents work. Rebecca, what I'd like you to talk about is I have my will now and I have my powers of attorney. And in my will, I give everything to my friend Jim, but he's not going to get anything because all my accounts are in joint names with my sister, or has my brother, if I was a single person, no kids, as my brother as a beneficiary. Right. What do I do? Yeah. Is that something we need to coordinate, or does the will take precedence over my beneficiary designation? Yeah,
so definitely that all needs to be coordinated. A common misconception that I have found among a lot of my clients is that the will overrides that and controls the disposition of everything, regardless of ownership, and that's not true. So there's different ways that assets can pass upon you dying. One of the ways is by will. Another way assets can pass is by operation of law, and that would be where you own real estate, jointly with a spouse or jointly with a child. That property, upon you passing away, is going to pass by operation of law to the surviving joint owner, and not pass according to your will. The other way is by contract, and that is where you have beneficiary designations. So maybe you have a money market account, and you put a transfer on death provision on that account where you want it to go to your friend, but your will says everything goes to your wife. Yeah. And it's important to know that account, upon you passing away, would go by contract to the friend that you named as the beneficiary. So the only assets that your will actually control are any assets that are in your name alone, that you do not have a beneficiary designation attached to. So that most commonly is real estate that you own in your sole name, your checking account, your vehicle, things to that nature.
Okay, so Jim, I have two kids. One lives a block away, and the other one lives in California. So I'm going to put my kid who lives a block away, I'm going to put him on as the joint owner of all my bank accounts, because that's what I need to do, right? So that he has access to those accounts if I become incapacitated.
No,
that's what my friend did, and my friend's friend, and my friend's mother, and et cetera did.
And it's a very common misconception out there that that's what you need to do.
Oh, by the way, excuse me. When I die, my will says everything goes to my two kids equally.
Yes.
So what happens?
So let's answer the first question. Don't even get into that situation, because
don't put my kid's name on my account.
No, you can do two different things that would be a much better option than putting one of your children on the account. Add them as a signator, or give them signature authority so that they could sign checks. So if they need to pay your bills, you could do that. They can write, but they don't own it. So when you pass, that account is still owned by you individually, and it will pass under your will, and in your example, would be split equally between the two children. That's option number one. Option number two, we talked about on the first half of the show. Have a financial power of attorney. Name that child as the agent under the power of attorney, so that if you want them to have access to those funds during your life to pay bills and do things like that, they can use that power of attorney. They can go to the bank will review the power of attorney, and then once that's been approved, they can then, same thing, write checks and access those funds and take care of you, essentially.
What are some of the negative consequences of me putting my son, who lives a block away, on my account as a joint owner?
So one of the biggest ones, there's two big ones out there that I really see. Number one, if you die, then potentially your son gets all the money in that account and it doesn't get split equally, which is what your intent was, right?
But I have a will that says it goes in joint name, or it goes to my 2 kids.
It doesn't matter. As Rebecca pointed out,
Okay.
it's going to pass by operation of law before it even gets to probate. It goes under the will. That money is essentially gone before that process starts. So it's going to pass that way. The other big issue, and I've seen this happen, and I just sit in front of clients and try to explain the situation, and they just give me dumbfounded stares. So mom has an account, does this exactly what you say, puts one of their children, mom puts one of her children on the account. That child passed away before mom.
Yeah.
Mom then has to pay inheritance tax because 50% of that account is deemed owned by that child. So she has to pay inheritance tax on her own money because under the law, she's re-inherited that 50%. So
Right.
another really good reason as to why not to put someone on as a joint owner, but use one of those 2 other options.
Yeah, that's a great idea, and that's a common mistake I see people make. So folks, do your power of attorney. Call your attorney after you're done this show, but not before you're done watching the show. I mean, call your attorney, make an appointment with him or her, and get those powers of attorney up to date. Rebecca, what happens if I die without a will?
So
It all goes to the state.
yeah, so if you pass away without
That's
a
not
will
true. Yeah.
in Pennsylvania, then Pennsylvania has an intestacy law that basically explains who gets your assets in that event. And so, of course, if you have beneficiary designations, those assets will pass by beneficiary designation. But anything that you owned in your name alone will pass by intestacy. And sometimes that can have a result very different than what your intentions are. And so a lot of people think, well, if I'm married and I pass away without a will, everything's just going to my spouse. Why do I need a will? And I was actually surprised to learn when I first started out in my law practice that everything doesn't pass to the spouse. So in Pennsylvania, if you have children with your spouse and they're not children of a prior marriage, then your spouse gets a certain amount of money off the top of your estate. But then it's divided half to the spouse and the other half to the children. So in my situation where I have, young children, I'm not going to want half of my estate passing to my young children. I want everything going to my spouse who's going to take care of my children. So that's a really important reason to make sure that you have a will, because the intestacy law is not going to take all of that into account. And the other thing it doesn't take into account is, appointing who you would want to be your executor, because again, that law is going to pick who would be your executor, who's going to take care of your children.
Be the guardian for the kids.
Right. So it has these default laws that might necessarily not fit into what you want your estate to actually look like upon you passing away.
Okay, those are 3 big reasons why you need to get your wills done right away, folks. Jim, what happens if I don't have a power of attorney and I become incapacitated? I get hit by a bus, I have a stroke, or I just become incapacitated. What the heck happens?
So I'm actually dealing with that with a client. Her elderly mother is now suffering from dementia, never did a power of attorney, unfortunately. So the only option we have so that we can get somebody in there and help take care of mom, make decisions for her, help move assets and things like that, is guardianship. And guardianship, while it's a great option, and it will allow this client, once we get her appointed, to do the things that she needs to do, it's a lot more complicated, costly, time-consuming than it is to do a power of attorney. Because with a guardianship, you need to have a doctor, at least one doctor, saying that the individual is incapacitated. They have to do depositions. You actually have to file with the court. There's a hearing. Potentially the individual that you're saying is incapacitated needs to be there if it's not going to harm them to be there. And it's a process that could take months, costs a lot more, thousands of dollars versus weeks and hundreds of dollars, or not even weeks, depending on how quickly you can move, to do a power of attorney. So in the power of attorney, the agent of the power of attorney is going to have more authority to act than a guardian is going to. The guardian is going to be more restricted under the law in what he or she can do as guardian with those assets. You can give your agent much more authority.
Right, and in the case where the person is obviously incapacitated, it's a fairly not easy, but it works itself out pretty quickly.
Yes.
But what if I'm just a little different? What if my older son thinks I'm 3 sheets to the wind, off my rocker, so to speak, and my younger son just thinks I'm eccentric. Then you have a matter, where the two kids are battling. Dad needs a guardian. I'll be it. Dad doesn't need a guardian. He just needs some support. Yes, he does. No, he doesn't.
And then you have Dad arguing, I'm not incapacitated. So you've
Right.
got three angles that are three
Right.
arguments being made.
And that's a big problem. That happens a lot, folks, where Grandpa is not doing something that son thinks is the best. So son thinks he should be incapacitated, rendered incapacitated, but daughter says, you know what, it's what Dad wants. Mm-hmm. So it's a tough situation with a power of attorney. The kids and their father, in that example, can, or at least the father can point one of the kids or both the kids to act on behalf of the dad.
Yep. And it's important to note that just because someone's doing something that you wouldn't do, that doesn't necessarily make them incapacitated.
That's right. And I
think that
use
was
the
point.
example a lot, and maybe you guys disagree with me, but if Dad wants to open the window and throw his cash out onto the sidewalk, it's his cash.
Mm-hmm.
You're not happy about it, son. You're not happy about it, daughter, but it's not your money.
Yep.
Mm-hmm.
It's not your money. He can throw it out. He can literally throw it out the window. Weird, but maybe not to Dad.
Mm-hmm.
So, all right, and we only have a minute or two left, but Rebecca, so I think hopefully we've established to everyone's satisfaction, you need a will if you're over 18.
Mm-hmm.
You need powers of attorney. I don't care if you're the healthiest, smartest person in the world. You need powers of attorney now. Think of it as new brakes in your car. You know you're overdue. They work fine on the way to work this morning. Get your brakes done, because otherwise, the time you need it, if you don't have new brakes, too late to get it because you're on your way into the rear end of the car in front of you. So do powers of attorney. But Jim, why do I need an attorney to do powers of attorney? Why do I need an attorney to do, to do a will? Can't I just get it online? Can't I go to the, I'm showing my age here, go to the stationery store and get legal documents? What do you think?
You absolutely can, as an individual, go online, go to the stationery store. There's no law that says that you need an attorney. But what the attorney can provide you is guidance as to what should really be in there. Do you want to accomplish things that are beyond the normal things that you might see in those forms? Not to mention, they can guide you and make sure that the documents you're signing meet Pennsylvania law. They're going to be upheld if they're ever challenged. They're going to meet all the requirements as far as witnessing, notarization, things like that. The attorney can add those two benefits. Plus, if you have questions, I don't think the stationery store is going to give you a lot of answers, or the internet. I mean, you'll get a lot of answers actually on the internet, but whether or not they're of any value, I'm not sure. So I guess there's three reasons why I think you should use an attorney for this stuff.
Well, Rebecca, my sister just had hers done. She lives in Alabama. Mm-hmm. Can I just take her docs and make them into mine?
You could. It doesn't mean they're going to work.
Right.
So each state is very specific when it comes to how the documents, need to look, the rules for signing the documents, and what needs to be in them. So it's really important to make sure that your documents are valid in the state of Pennsylvania.
And Pennsylvania has some real particular power of attorney rules and regulations, especially over the last 3-5 years. Mm-hmm. They've become really particular, they meaning Pennsylvania. So don't take documents off the internet. Don't take documents from your sister who just did them in Texas, because chances are they're not going to comply with Pennsylvania power of attorney law. Mm-hmm. What in the short couple of seconds here, Rebecca, real quick, throw to the audience some events that may happen in their lifetime that should cause them to revisit their docs.
Mm-hmm. Definitely, any kind of change in family situation, so marriage, divorce, the birth of a child, a major change in your net worth, a recent diagnosis with a new illness, things like that definitely would trigger you to pull out those documents and look at them to make sure that no updates are needed.
Awesome. Well, Rebecca, thanks. Jim, thanks a lot. Folks, thanks for watching Legal Talk, brought to you by your law firm. That's O'Donnell, Weiss, and Mattei Law Offices. This is our 62nd year at 41 High Street and 347 Bridge Street. www.owmlaw.com. Your life, your business, your law firm. Have a great night.